On July 9, 2016, I was in Baton Rouge because I've been asked to come by local organizers so that we could be a part of the protest, so we could help people, give advice, and that we could use our social media platforms to amplify what was happening.
City police, you're under arrest.
What?
Don't fight me. Don't fight me.
I'm under arrest.
I got arrested very quickly. That night, I stayed in police custody for about 17 hours, and one of the things that I realized when I got out was that I'd been sued by a Baton Rouge police officer. I have no clue when this rock was apparently thrown at an officer, but I did not throw a rock. And I certainly don't remember any moment where an officer said that he got hurt.
The question in this case is whether DeRay Mckesson can be held personally liable for the alleged violent actions of someone else. This is an incredibly important First Amendment case. When I go to a protest that has hundreds or thousands of people, I can't possibly know what someone else in that protest might decide to do. I can't even know if that person shares my beliefs. Perhaps he was sent undercover by a government agent or by a movement that opposes what we're doing. The Fifth Circuit has essentially said that I can be held liable for what someone else does if it was foreseeable that there might be a police-citizen interaction that could lead to violence. By that standard, I really think that every movement for social change in this country is jeopardized.
The goal of the lawsuit was to actually have a chilling effect on organizers, to make people so afraid that if anything happened during a protest where they were just present, that they might be held responsible for it, and it would just be really harmful.
All the most significant marches of the civil rights movement involved civil disobedience. They involved sometimes violent interactions between citizens and police officers. They involved dogs, they involved fire hoses. We know from the civil rights movement that the FBI and J. Edgar Hoover sent agent provocateur into the movement to try to gin up violence, to try to discredit the civil rights movement. And if the law had allowed anybody to sue the leaders of the civil rights movement for damages that were not caused by them personally, those movements would have been bankrupted before they could have achieved any kind of social change. And that's what's at stake here.
I know that the goal of this is to make people too afraid, and I won't be too afraid to do this work, but I'm hopeful that the Supreme Court will hear this case, and I'm hopeful that they will overturn the Fifth Circuit.